everybody. Thank you for joining us today. We are scheduled to begin the webinar at noon. We still have a couple of RSVP'd attendees that haven't logged on, so we're going to give just a minute to make sure everybody can join. During the webinar at any time, if you have any questions, please either post a question or there's a mechanism to raise your hand. Please do that, and we welcome questions throughout or at the end of the webinar. We'll try to leave some time at the end to answer questions as well.
So it'll be about 50 minutes with about 10 minutes of questions at the end.
Exactly. All right, good afternoon, everybody. Thanks for joining us. My name is Eric Boughman, and I am joined here with my partner, Gary, and I'll let Gary make his introduction.
I'm Gary Forster. Thanks for attending. We appreciate it. Hopefully we'll try to hit a few practical issues today. We've got about 50 minutes, and then we'll take about 10 minutes for questions. Today we hit kind of a strange topic, why you shouldn't do asset protection. As many of you are likely aware, asset protection is a means of planning, and what happens by using trusts, mostly trusts and LLCs, to avoid future unknown creditors is basically like litigation insurance. What we're talking about today is some of the cases associated with people who really didn't do very good planning, but the cases reveal a lot of what the judges reviewing these types of matters will react to, especially when they have someone who's a bad actor or a criminal. It's not necessarily applicable to our practice because we only do the planning and an analysis if someone actually has an issue. But it does enlighten us as to how courts will react if in fact one of these plans is challenged. We've never had a plan breached because we follow these cases and some of the factors associated with some of the, where the court has told the bad actor, look, if you had done the following things, we likely would have no problem with your plan. Eric does the litigation associated with a lot of asset protection, either trying to reach assets or trying to defend assets, and I do a lot of the planning. This is Gary. I do a lot of the planning, and we work together on a lot of matters. Oftentimes people can do actually a lot of planning even though they may have some small litigation or some potential claim.
All right, so we'll move into our presentation. And as noted, this is titled The First Commandment of Asset Protection, and just as a little background, we intend to do one of these each month and cover throughout the year what we've titled the 11 Commandments of Asset Protection, and these will be tips that hopefully will be helpful for the viewers. We will reference a lot current events, and this will be a fluid presentation because as the law develops even throughout this year, we'll try to keep everything as current as we can. So initially what we'll discuss is a little bit of background. What is asset protection? A term is used a lot, but there's a lot of misconceptions. We'll talk about how asset protection, attempts at asset protection fail. We'll talk about the importance of a party's intentions when they engage in mechanisms to try to protect assets from creditors. And we'll finish up with some tips for planning and a little conclusion and Q&A. An asset protection is essentially a mechanism by which we utilize existing laws, which include available statutes and case law, to insulate businesses and owners from risk. And there's questions about whether or not, there's questions about the legality of asset protection, morality, and whether it's ethical, whether you should be able to hide from risk or hide behind legal mechanisms to avoid creditors. But ironically, these questions don't come up in the context of insurance. There are situations where we have, where there's public policy that actually promotes certain protection of assets, such as in Florida, where we have a homestead protection. So what we're talking about today is entirely legal, ethical. In fact, we think sometimes as attorneys we have a duty to advise our clients of these mechanisms that are available to them. And as for morality, well, it's an individual choice. If you can always engage in asset protection, keep yourself protected and shielded from creditors, but if you think you have a moral obligation to pay, regardless of your legal duty, you can always handle it as you choose accordingly.
You can always choose to
That's
pay.
right.
Basically, what we try to do as asset protection planners is put the person with assets in a similar position to someone who is without assets in a lawsuit. So if a group, for instance, is sued on a commercial matter, if one of the 3 or 4 parties associated with the lawsuit has all the money or the bulk of the liquid assets, what you see in litigation is a shift of focus toward that person. So what we want to do is try to bring some of the focus of the plaintiff's attorneys away from the person with the assets through some planning.
Skipped ahead there. Sorry about that. So, these are some of the things that asset protection is not. And there's, like I said, a lot of misconception about asset protection. A lot of this comes from bad actors. I point out this one group. You can look them up yourself on the internet. There was a group called the Asset Protection Group, and they were selling. They were actually trying to sell not only asset protection plans, but sell planning opportunities to anybody who could come up with $10,000 and pay them. And if you paid this asset protection group, you could own your own business and you could do asset protection planning. And that's what gives this a lot of what gives us a bad name. The folks who were behind the asset protection group, both of whom have been criminally charged. William Reed was a disbarred lawyer, and Rick Nieswanger was a convicted felon. So no surprise that they got themselves into trouble selling asset protection planning.
Well, also a lot of times this word asset protection gets thrown around, and it's really no surprise that a lot of the public is not aware of what good planning is. So I think the key is to really seek a professional who's been doing it for years, a licensed attorney who has written on the subject, or if there is an issue and you're looking to see what the exposure is, a similar type litigation attorney. So it's not reacting. Reacting to a claim is not asset protection planning. It's the reaction. It's these people who try to do evasive measures is where they run into trouble. On our side, it's somewhat fortunate in terms of the creation of cases that kind of lead us to help us in planning so that we can avoid the issues raised by the judges.
So we talked, I mentioned earlier about policy considerations. And, there are states, in a state where I used to practice in Nevada, there was a push about 12, 15 years ago for tort reform. And that was a big buzzword across the country, and still is in some areas. And Nevada had a ballot measure on tort reform, and ultimately the doctors and professionals who were getting sued in malpractice claims, they were running scared because they couldn't afford insurance, they couldn't get insurance because of out-of-control verdicts. And Nevada has, in the past 10 to 15 years, and even before that to some extent, become a very popular area for asset protection. And the reason why is in part because they have very strong laws that protect, for instance, single-member LLCs and protect trusts without exemptions that you find in other states. They have a very favorable view, both legislatively and policy-wise, and this is reflected in court decisions where, for instance, last year a law firm was sued for being involved in moving some assets for a debtor, and the Nevada Supreme Court said, we are not going to allow third-party tort liability against law firms for fraudulent transfer claims. So you see this reflected in policy, and we see it in Florida where we are, again, with homestead exemptions and certain exemptions for retirement accounts and for head of household wages. And asset protection as a planning mechanism utilizes these different tools, and we think, again, that really if you're in a situation where you're potentially going to be at risk of being sued, which is many people, anything from car accidents to professional practice, it's very responsible to engage in some mechanisms to protect your assets.
And one of the complexities of doing the plan is to try to take advantage of these policies in different jurisdictions. So if you're living in Florida, you'd like to take advantage of a Nevada LLC or trust, well, that trust really should be set up in a certain way as to try to take the most advantage of that of the Nevada jurisdiction, the Nevada law. And we have a line of cases that help us in establishing that trust so that if it's challenged, Nevada law will likely be implemented.
So as we talked about, some of the mechanisms, and Gary does the planning here in our office. He's written a book on this, actually, that covers these issues in depth. But we have, public policy favors giving people a fresh start in circumstances. Public policy is reflected through our laws, favors exemptions for certain assets to make them unavailable to creditors, and we also used corporations, trusts, LLCs traditionally throughout time to insulate risk. And asset protection is no different. It's just utilizing the current laws and staying on top of what's going to be effective today. And surprisingly, because of the fluid nature of the practice and the law and the way it changes and the interplay between different jurisdictions, it's not always clear. And so we'll point out a couple cases, I think, that'll show you that today. Now, starting from a legal perspective, the place where we always start is that prior to a judgment, a person has a right to use and dispose of assets as they choose. And there's a Supreme Court case where this became an issue. If you want to, for instance, try to freeze somebody's assets in advance of a judgment, it's a very unique situation. It's very difficult to do that. You also typically have to post a bond so that if it turns out that you've frozen some asset and the court finds later that that was in error, you can be subject to paying damages and fees to the party whose asset was frozen. But there's no, as far as any law that restricts what you can do with your assets, there's no standing law or policy in any state that says you can't move assets just because you have a creditor.
So one thing we find with clients is that there's a fear. Sometimes they'll come in after they've made a transfer. There's no real penalty unless you're dealing with some kind of government claim to moving assets. You can move assets at your discretion. The next topic you'll see on the next slide is so how plans are unwound, and kind of leads to the idea of our kind of odd title, why don't do asset protection, why you shouldn't do quote asset protection, close quote. And because plans are unwound in two ways. One is the actual structure of what was created. In other words, if you use trusts or LLCs or a different format, can be disregarded. So they break through the structure to reach assets. That's what the plaintiff would claim, that it's somehow a sham. And the other way to do it is to pull assets back out of the structure, put them back in the hands of the defendant so that the plaintiff can reach them. So you can either break the structure, you can pull the assets back out. We'll go into all of those causes of action. It's actually what Eric does pretty much every day. And one of the probably the most significant cause of action is this fraudulent transfer claim, and you will talk more in detail below. But it has to do with the intent of the defendant. In other words, did the defendant intend to move an asset away from a creditor? And this intent is tempered by having other intentions beyond asset protection. Why not to do solely asset protection for your as your intention for the transfer? So the idea is there's no penalty to transfer, but if someone's going to come after the asset, they're going to do it either by breaking through the plan, or they're going to unwind the transfer, put the asset back in the hands of the defendant. And then we'll start to talk about some of the cases. Again, don't get the impression that we suggest you plan for people who are criminal or who have bad intention. It's just that these cases really illustrate how courts react to sham structures or fraudulent transfer.
So let's talk about a case that really kind of brings out the basis for the topic, or the title of our seminar today. And this is a case that comes out of the bankruptcy court in South Florida. And there were some individuals who were subject to a big claim out in California. They moved to Florida, and they were trying to both get away from the creditor who was chasing them in California and move assets away from that creditor so they didn't have to use them to satisfy a judgment.
Clear fraudulent transfer.
Yeah, it was these folks. They just, in that circumstance, if you're already subject to a judgment, contrast that with what we mentioned earlier. Prior to judgment, you can move assets freely. Once a judgment's been entered, you now cannot move assets freely. What you do is subject to being unwound and can get you in trouble and can get others in trouble who are involved in those transfers. And then the period between the judgment and before a lawsuit is ever filed, where you have the lawsuit being filed, sometimes they can go on for years. That's the gray area. But here in this Cutelli case, this was a clear fraudulent transfer. And here's some of the things that jumped out at us about this case. This is a couple of years ago, fairly recent. But first, the court noted that they had obtained some communication, the trustee in the bankruptcy case, that the debtor was seeking advice on asset protection and offshore accounts, and noted that a couple of times in an opinion where the court found that the debtor was engaged in a scheme to defraud creditors. And they had reached out to an attorney who had advertised asset protection services and had talked about the ability to create entities in other jurisdictions and offshore. Again, nothing wrong with that. But in this case, because of the bad actors and the way they went about it, the court just jumped all over those terms. And so that gets us thinking, well, maybe we want to, sort of tie this in so it doesn't look like your intent is to avoid creditors. But even when you're doing legitimate planning, you have to consider the fact that courts sometimes latch on to some of this language. Judges and courts want their judgments enforced, and they want to see creditors get paid, and they want to see bad actors pay their debts. And so these are all considerations that, and a judge could see somebody in one case, and it could be a terrible actor, and the next day you show up in court and you could do everything right, but just catch the judge right behind something else that happened that sheds a negative light on your circumstances.
But acting in good faith, you'll see in the cases, acting in good faith is very significant. In other words, if these people were really going like criminals, but if you actually have a problem, you can do. There are certain transfers, for instance, that you could do. They may be subject to fraudulent transfer. For instance, in Florida, you can purchase a homestead. if it's your principal residence. But when you have a situation where someone's literally running from the law, or just flying in the face of a court, it's just not going to go well for them. It's not going to go well for them at all. We don't do a lot of that work because we focus principally on the planning. But for instance, this Cutelli group was really kind of almost like a criminal venture, and the court latched onto the idea that they basically said to their attorney that they want to hide everything. Well, hiding doesn't work, and it just went kind of downhill from there for them.
Now, how do we know what they told their attorney? And for some folks out there, maybe thinking, okay, well, you have an attorney-client privilege. How do you know what communication occurred? Well, the court was so put off by these actors that first, the court found that the fraudulent transfers that the debtors engaged in, and we'll talk about what exactly is a fraudulent transfer a little bit later, but the court here said that fraudulent transfers created a basis for what we call the crime fraud exception to attorney-client privilege, and that is that all communications between attorney and client are privileged and not subject to discovery by a court or anyone, but the exceptions to that are if the communication is used for the purposes to advance a crime or commit a fraud. And
this is the bankruptcy court.
And here the bankruptcy court, which is almighty in bankruptcy world, once you subject yourself as a debtor to bankruptcy, your assets, everything becomes subject to the control of the court. First they found a crime fraud exception and were able to get communications between debtors and their attorneys. But actually they went one step further. And in bankruptcy there's this notion that once you become a debtor in bankruptcy, your assets become assets of the trustee, and the trustee also in certain circumstances then owns the communication that you previously had with your attorney, and so therefore can obtain that communication. And there's another issue with attorney-client communication where if two parties, if there's two people who go to an attorney for work on a particular matter, there's a right for one of those parties to share in the communications between the other party and the attorney. And it's a joint client or joint interest, common interest, and it protects the communications as between those parties from everybody else. But if Bob and Jane go into an attorney and Bob has communications regarding a deal, Jane's entitled to find out what those communications are if she's also retained that attorney for the same deal. So putting all that together, you have a couple of really exceptions in the attorney-client privilege arena, and the court put all those together to say, well, there's a crime fraud exception, plus the trustee's entitled to all the communication, and the attorney who was involved with the debtor to make some transfers to a third party, well, he also represented the third party. So the court ordered the turnover of communication not only of the debtor and the debtor's attorney, but also the third party that the debtor was trying to transfer assets to. And that's a really unique decision. I mean, for the court to basically get carte blanche access to all that communication is something.
Well, it was unique when this came out in 2013, and this was kind of a sacrosanct thing in Florida where it's very, very difficult to reach attorney-client privilege, and we actually had a case years ago, a bad actor asset protection case, and the attorney-client privilege was preserved. It wasn't broken by the crime fraud exception because fraudulent transfer isn't fraud. It's kind of a detailed analysis, which is beyond kind of what we're doing today. But it was very protected. But we recently run headfirst into a Supreme Court case that came out last year called Husky, and the Supreme Court of the United States pretty much unanimously said that fraudulent transfer is common law fraud. And if it is, then the attorney-client privilege is not going to be protected. So where you even had a group of attorneys recommending fraudulent transfer because we had mentioned there's no penalty to fraudulent transfer, but creates some practical barriers for the plaintiff. You can't really, even those attorneys can't really do that anymore because I think they give up. If the Supreme Court is going to be enforced, I think they're going to have to give up the attorney-client privilege. There's no way they're going to get around it.
Yeah, there'll be still some arguments regarding Husky. and its impact, because people who are trying to limit the effect of that decision are going to say, well, that was only in the context of interpreting a particular bankruptcy statute. But it's a short opinion. This Husky, it's a U.S. Supreme Court decision where an individual took assets. A company was being chased by, it was business assets. A company was being pursued for a debt, and he took assets from one company where he wasn't even a full owner. He was a part owner in one company and moved assets to another company, and he ended up being pursued by the creditor. He ended up filing individual bankruptcy, and the bankruptcy court found that his conduct was fraudulent, such that he was not able to avoid it in bankruptcy. We'll have another seminar later where we'll probably talk a lot about that particular decision's impact.
The fraudulent transfer actions is the same as fraud for certain purposes.
But for that particular purpose in bankruptcy, but there'll be arguments to try and limit it, and it'll be interesting to see how a place like Florida, for instance, or Nevada, where they've said that a fraudulent transfer is not fraud, how that gets interpreted for other purposes here in the state.
Another reason not to do intentional asset protection without doing something else as well.
and let's face facts here. I mean, a lot of people, I think, when they talk about asset protection, where we hear it a lot, we get these calls from other folks and even from other professionals. I got a call from a lawyer not too long ago. My client's just been on the wrong side of a judgment. She's got some assets. She wants to move them into an LLC in Florida and maybe move them offshore. And they think that's asset protection, and it's not. It's too late. It's like getting, you're waking up to a fire in your house and then calling them to make sure you have fire coverage. It's not going to work. And that's the issue with asset protection, really, and that's the point we want to drive home today, is that you can't wait until you need it to do it. It's too late. That's not asset protection. That's just reacting. So talking about how these plans are unwound, other mechanisms, this was one in Cutelli. They tried some self-settled trusts as well in Cutelli, the case we just talked about. We see a concept of alter ego, where you create maybe an entity or a trust and try to move assets and shelter them that way. A lot of those plans are perfectly fine and legitimate. And Gary does trusts. He does offshore trusts. He does them, onshore, different jurisdictions. We use LLCs all the time. But you have to respect that the separation of those entities. Oftentimes people will create an LLC, and then if you create an LLC and then you just use the same bank account for your own stuff and for the LLC, you're going to have problems. Some jurisdictions don't recognize, for instance, self-settled trusts, and they find if you settle a trust for yourself, one of the ways that people can attack those if you're a creditor is to say, well, it's basically you've moved assets into an entity that's not a recognized legal structure here in Florida or whatever jurisdiction you're in. And there's a big case in Washington, for instance, where this happened a couple of years ago. And so we can basically ignore that structure and just treat it as an alter ego, as an alias of you. And we see that fairly common. That's one of the mechanisms of attack. It's also a mechanism by which corporations are attacked to try and get to the individual shareholders when you go through a veil-piercing analysis.
So that's a combined attack. In other words, let's say, for instance, someone had created a Nevada trust for themselves and lived in Florida. So your first issue is Florida does not respect a self-settled trust. In other words, if you create a trust for yourself, it's not going to protect the assets inside the trust. So a good plaintiff's attorney is going to say, well, we're going to apply Florida law. What that means is unclear at this point, because these entities are formed under a statute in a particular state. How Florida law applies is sometimes very unclear. But it is recognized as a viable argument to say you have a Nevada trust, but we're going to apply Florida law, not Nevada law. It's going to become a Florida trust. It's actually been successful a few times. It's because the judges, again, want to enforce these judgments. And then, if in fact it's a Florida trust, it's over. The defendants lost. The assets are gone because they're not protected. If you can cause it to be a Nevada trust, Now you have to look at, okay, under Nevada law, is this set up right? Or is it really a trust? Is there really a Nevada trustee? Is anyone else a beneficiary? That's a big one. Is anyone else a beneficiary? Because as you'll see in some of these cases, someone sets these up in the wrong jurisdiction, and even though they're trying to pull it into a non-self-settled trust jurisdiction, they go through a number of factors which these defendants fail. They've got the trustee at home in their home jurisdiction, not in Nevada or Alaska in terms of a lot of the cases. They've got the assets outside of the state of the trust, and they're basically operating as if the trust doesn't exist, and that's just a recipe for disaster.
So, following up on that, let's talk about a couple actual cases where that happened. I mentioned there was one in Washington. This is this In re Huber, and Gary, you want to talk about Huber a little bit?
Well, Huber was a contractor, if I recall correctly, who had run into financial problems. So there was this overshadowing issue of fraudulent transfer. In other words, as Eric had mentioned, fraudulent transfer can basically be, it is based on intent. So if you intend to avoid a creditor, whether they have made a claim or filed a lawsuit or not, you're going to have an issue. They're going to claim that you moved assets away from them and will have the right to draw it back in. So he already had problems. And so what he did was he said, okay, I'm going to go ahead and form a trust for myself in Alaska. But I'm going to leave the assets here. And all of the significant connections associated with the assets and the trust are going to remain in Washington State. And what happened was the court basically, every argument in the book was made, and the court basically ruled in favor of the plaintiffs on everything because he did not lock up the assets in a viable entity that followed the rules. He had no control over the assets. For actually that was Alaska trustee, and leaving the assets in Alaska. He didn't really do that. So the court broke right through it. You can see this separate case, which is kind of near and dear to us, is an LLC case, Wells Fargo Bank v. Barber. This raises a really significant choice of law issue. It's the same type of thing. She did obvious fraudulent transfer, but she created an offshore LLC. She was crazy enough to leave the accounts right there in Florida, waiting for the judge to act on. She totally controlled the accounts, and she left the LLC as a single member LLC. So the issues come up. With trusts on the choice of law issue, you can kind of move the law around a little bit, even though the trust the language of the trust is going to choose the law, and the trust is set up under a certain statute. They have different, they call situs and operational law for trust. You can kind of play with that. With LLCs, it doesn't have that. You've either got a foreign LLC, you've got an LLC in Florida, or you've got an LLC in another state, and that's kind of, you've either got a Delaware nickel, you've got a Nevada nickel, you've got a Nevis, this was Nevis West Indies nickel, or you've got a Florida nickel. So Eric and I argue about this, but actually the setup of these LLCs is significantly different under every jurisdiction. So she actually had properly set up a West Indies LLC, Nevis West Indies LLC, and the court would have none of it. She was a bad actor. She moved assets away. I think she was a guarantor on some massive debt.
Yeah, it was $61 million on storage units in South Florida
that crashed.
And in order to crack a single member LLC in Florida and foreclose on the interest, you have that right, but you first have to make a showing that it's reasonably certain that the creditor won't be paid just for distributions from the LLC.
Right. And that was clear.
And so the judge said, well, she owes $61 million, just like Austin Powers dollars, and she hasn't paid anything so far. And I think we can reasonably deduce from that that the creditor is not going to get paid anytime soon
So,
here. So we'll have to
their
foreclose.
only obstacle was, well, it's not a Florida LLC.
They had to beat
So
that
they
argument.
just kind of made it up and said, no, it is. It is a Florida LLC. They all looked at each other like in the Stork movie. I have little kids, and they, yeah. And so they called it a Florida LLC. So now I don't think that that's totally worked its way through all the appellate system, but that's kind of what you're running up against. Now, take that same fact pattern, but change it to, okay, all of the accounts were set up in Nevis, or they were set up in whatever, Barbados. Well, now you've got a different situation. Now she's got an LLC that's still governed by Nevis law that does not allow the creditor in. Nevis, in the statute, we just actually rewrote this fraudulent transfer section of the statute, doesn't allow for remedies ruled on by a foreign court. So the court has no jurisdiction, and the plaintiff is suing in Florida. I think the plaintiff on that one would probably have to go to the West Indies to try to create a charging order on that LLC with assets abroad. And it's kind of like when we talked about the trust in another jurisdiction. You have to respect that trust in Nevada. You probably have to have your assets in Nevada, and your trustee would be in Nevada. Well, on an LLC, it looks like the same thing's going to be true. This woman, Miss Barber, if she would have created that same LLC in West Indies but had the assets there and maybe a manager there, I think the plaintiff would have had a hard time, even though she was a bad actor.
Hey, actually, we got a question, which is nice to see. Well, if you have any questions, type them in the little box there, and we'll address them as they pop up. And somebody writes, what could Huber or Barber have done to make these viable? And Gary just talked about that a little bit with some of the things that Barber could have done.
Because Huber's more common. So, that's a domestic.
So let's talk about Huber. So this guy, he's a Washington resident. He creates the Alaska Trust, puts all of his assets in it. And this is what the court pointed out. The court said, well, the trustee and the settler, the guy who created the trust, are both in Washington. The court looked at the location of the assets. They were all in Washington. The domicile of the beneficiary, who was just, again, the same guy who created it, just himself, he was in Washington. And then the court also looked at Washington's strong, and this was from the case, he said Washington has a strong public policy to disallow self-settled trusts as a planning vehicle. And so he could have made it a little, one of the things we talk about, kind of pigs get fat, hogs get slaughtered. Leave some assets exposed. He put Washington real estate and vehicles into an Alaska trust. That's just not going to work. Because if you have dirt in one state, the state there is very likely to apply that own state's law. Now with Barber, distinguished that she had bank accounts, so she could have moved those. She should have never had those. But another thing I'll point out about Barber, it doesn't jump out at you, but when you read the case in the background, one of the things that the court spends a little time talking about is she moved those assets quite a bit. She got sued. Yeah, right. She sold a house, which she actually had protection from the homestead, but she sold it. She moved the money she moved it into like 3 different accounts. And when you start doing things like that, that comes back actually to the topic of stuff.
She had the homestead.
You could have kept it in a homestead. You can sell the homestead and put it into another designated homestead account. You could sell the homestead and take money and put it directly offshore in an offshore account in an offshore entity, and make the argument that defend to say, well, these were exempt assets to begin with, so I just took exempt assets and moved them offshore. That's not a fraudulent transfer. There's things she could have done, but instead I think she got too cute too. And that's what some of these, we'll talk about another case where a guy, thought he did, told the court, well, I did some asset protection, I don't own anything anymore. That's the kind of thing that's going to get you in trouble. And so I know we don't want to run out of time and not be able to talk about our cases. We've mentioned this a couple times, fraudulent transfers. It comes down to intent. And this is what arises. We get people who contact us for quote-unquote asset protection in the face of a judgment, really what we're talking about is somebody trying to avoid a judgment, and that's where you have fraudulent transfer implications, and you got to be really careful. And by the way, not only attorneys, but we've seen, here in Florida, financial planners, banks, attorneys, accountants be embroiled in litigation for just simply helping their clients. There's one with USB Payne Weber a few years ago, just trying to help their clients, and the assets get moved, and all of a sudden, you get drug into a lawsuit yourself. That's no fun. We'll talk about intent with respect to unwinding plans with a fraudulent transfer, and that's really the issue. It's the timing and the context, and a fraudulent transfer gets unwound either through a demonstration that a debtor intends to avoid a creditor, and we do that through what are called badges of fraud, is what the courts call them.
Indications.
And things like, that I transfer it to my mom, did I transfer an asset as a gift versus a legitimate sale, things of that nature. And there's a whole list of factors that courts look at.
It's state of mind. That you have the state of mind to avoid the creditor.
And what we try to do here, and there's, in certain situations where we say, okay, why are you doing your planning? Why are you wanting to restructure ownership of your assets in some way, and try and tie that in with something else? Typically, estate planning, changes in business, changes in life circumstances. You have a new business partner. You just had a child. You have a sick relative. Come up with another reason why you're doing things to offset the intent. We call that coming up with something that we can look at as a legitimate supervening purpose for your motive. And then so that's one way to unwind a fraudulent transfer, is just by showing actual intent to avoid a creditor. And the other way is through constructive, and a constructive transfer is essentially where the court just looks at objective factors, and it generally comes down to, are you insolvent? Do you have a creditor? Are you insolvent? Which means basically they're not paying your debts as they come due, or a test of balance sheet insolvency. And did you make a transfer for less than reasonably equivalent value?
So if that basically, even though someone can't prove intent, they can prove it constructively if you moved your assets and there's nothing left for the plaintiff to get. Is the bottom line on that one. And this is the typical successful argument. The alter ego, where the structure is no good, that's a very difficult argument. But the fraudulent transfer, a lot of people just transfer everything in to try to get away from a creditor. It's very, very common for people unrepresented by competent counsel. They just move things, and you'll see on the complaint the first claim is fraudulent transfer because it's very easy to prove. They became insolvent. You can't say, oh, I got a trust beneficial interest back for my assets, or I got an LLC interest back, because the only thing that counts in that solvency calculation are things that are available to the creditor. We have an initial case, this Kilker case, which is really telling in terms of trying to have another intention to, besides asset protection. This was a engineer / contractor who put pools in for development. He does what looks like fairly good planning. He does asset protection trusts in Nevada, which has a very good statute. He unfortunately basically put everything he had in there. He did not have a creditor pending. He was in business, but he did not have a creditor pending. He put everything in there, and he was the only beneficiary, which, where you run into this sham type of situation. But, 8 years after the construction, he starts to get sued by the pool owners, by the swimming pool owners, where he had done the engineering work. And, there was basically the court case was so poorly done, but there was an overriding flavor to the decision that talked about the whole thing just being a sham, in light of the fact that It was in another jurisdiction. I think it was California. He was California.
Yeah, he was in California. He got sued in California.
And they don't have a domestic asset protection trust. So there was this overriding sham argument. But the real telling stuff had to do with the idea that the court said that if you're doing asset protection planning without another purpose, and he basically told the court to shove it. I did my asset protection planning, na boo boo, and not a good idea. They said that basically if that's your only purpose, I'm unwinding it, even after the statute of limitations had run. So it's kind of a ridiculous decision.
Really, a couple things here. He didn't have a creditor, as Gary said, when he did the planning. He had done swimming pool site work in 2000. He didn't even do his planning until 2004. He didn't get sued until 2008. And in this case, this decision actually comes out in 2012. So 12 years had passed between the time he did the work, 8 years since he'd done his
there's
set
no
of his
real
trusts.
legal claim.
And but the court really didn't like this guy. And I don't know what the situation was. If it really came off that bad as in his testimony. But he should have been safe. He should have had a couple of defenses to any claim, but he ended up getting hit. But in his testimony, and really, I think there's two things that Mr. Stillman did wrong. One is courts like to clear their dockets and get settlement, and here the first thing that he did wrong is he agreed to a settlement, but then he almost immediately reneged. So he signed a settlement, gets out of a lawsuit, and then he doesn't pay. And so he gets drugged back into court to enforce the settlement. And when he got drugged back into court, that's where he was testifying, and he explained that he'd engaged in asset protection and he didn't leave any assets of any more than value of $500 or more in his own name. And so, like Gary said, na, you can't get me. And the court said, well, we're going to disregard those trusts.
Yeah, and it'll be interesting to see if there's an appeal or the California Supreme Court hears that. What this is all trying to come down to, all these cases, is there's kind of some ingredients that you have to have in the planning and not reacting but planning, which we hit in the overview. I think it's in the old outline as well, which we did an in-house seminar with an outline. We can add that to anybody who wants. We'll just send us an email.
Yeah, we'll post it on. We have a site. We'll put it on our LinkedIn.
So you don't want to be on our LinkedIn site, exactly. You don't want to be a bad actor the way he reneged. You want to have other purposes. You don't want to tell the court that they're not going to be able to get anything because you did asset protection and nothing else. You don't want to transfer all your assets into one structure. It really suggests that you're trying to hide. And you want to have other beneficiaries. You want to have, if you do a trust or an LLC, have other members, have other beneficiaries to the trust. Make the court think about unwinding a transfer. If we're going to talk in the next case, we don't have that much time. It's called the Stewart case. It's next. But he really made the court think about the fact that he had put money in, and if the court unwinds the money, that someone who needs that money is going to lose out. It's not a sympathy plea. It's just that it was a valid transfer to a trust. And if there's no real legal basis for unwinding it, the courts are really going to be reluctant to unwind it. Whereas in Kilker, it was only the defendant that was the beneficiary. It's a huge issue. Let's go on to Stewart.
Yeah, and a contrasting case. So Kilker does everything right technically and legally, and he gets hit with a fraudulent transfer claim that is successful. Now we've got a case. This is a little bit older case in Florida from 2001, but the facts are interesting to compare against Kilker. And in this case, Stewart was a guy who had been divorced, was ordered to pay his ex-wife alimony, and he defaulted on that. And he filed for bankruptcy protection. But in the meantime, he'd made transfers of assets of a little over $1.8 million in the brokerage accounts that were owned by his current wife. And the court reviewed these transfers and and found, remember earlier I mentioned badges of fraud. The court found several badges of fraud present in this case. The transfers were to an insider, his wife, the current wife. They were concealed. He didn't disclose them. They were made after he'd been sued by
his whole ex-wife.
By his ex-wife.
Yeah.
Actually, and the suit was for attorney's fees. And the transfers comprised substantially all of his assets. He didn't receive any compensation. And so the court went through these different factors and said, well, there's a lot of factors here showing potential fraud. But the court also said that, in considering the debtor's intent, it's also appropriate to conduct a subjective analysis or a subjective evaluation of the motive, and in addition to standard badges of fraud. And here, Stewart had explained that he had a son in his second marriage who was born prematurely, and he feared that there might be long-term consequences from the premature birth. And he also testified that he would have difficulty himself getting life insurance because of certain medical difficulties. And so he had transferred these assets not to avoid the ex-wife creditor and her attorney, but simply to make sure he provided for long-term care for his prematurely born son. And this goes back to what we talk about is when you're doing the planning, what's the purpose? Find a legitimate supervening purpose and hang your hat on that, and avoid presenting the court with an option of, well, I can either enforce a judgment by finding that your asset protection is invalid, or I can consider, what were there other legitimate reasons for what you're doing, and really good policy, frankly, in our view, is upholding the law. And in a case like Kilker, the law should have said that this guy, that his planning should hold up, but it didn't because the court didn't like him. In Stewart, there was much more leeway. The court could have easily found these were fraudulent transfers, but didn't. And it's a good lesson in.
And then we have, and it is a lesson. And the final case is even more bizarre. BB&T versus Hamilton Greens, where another guarantor of a huge debt clearly fraudulently transferred assets abroad to a foreign trust. It was kind of botched by the attorney, by the plaintiff's attorney in the first round of that case, which was just a wild decision where they let the defendant kind of get away with the transfers. But they came back with the fraudulent transfer argument. But it was very interesting the way very competent counsel on the defendant's side, he kind of tampered the intent somewhat, because this guy had, basically he wasn't the only beneficiary. He was taking only cost of living distributions from the trust. But that at the time of the transfer, which is when everything is looked at for fraudulent transfer in terms of solvency and intent, the property transferred really was not underwater. So it suggested that the intent was not fraudulent. And he won the second round of the case as well and got to keep his trust assets.
Yeah, so we kind of went through skipped over the constructive. We talked about constructive fraudulent transfer a little bit earlier, but we'll have that in the written materials and you can see what the factors are. But what Gary's referring to is that in a constructive fraudulent transfer, you show just the transfer for less than reasonably equivalent value at a time when you're insolvent. And here the guy he was a guarantor on a loan, and basically he had a $3 million construction loan, and he had, right after the bank, the loan went into default, the guy was sued along with the developer and other guarantors, and then a few months after that, he created an offshore trust, transferred most of his assets into the trust, and then the bank obtained a judgment. And what the guarantor said was that, well, there was no reasonable expectation that he'd owe any money because the property that the bank foreclosed upon was worth $15 million, and the judgment was for less than $5 million. And so he argued against the constructive intent, the insolvency issue, and a transfer for less than reasonably equivalent value. And he said, I wasn't insolvent, there were no solvency issues, and in fact, I had no expectation that I would owe anything. And that's what Gary referred to as the value of the property was more than the debt. Now, of course, we know real estate crashed in the early 2000s.
That was later.
But the real estate crashed after the fact, and he made a very, very good argument. He gave other subjective reasons for the transfers and ultimately was successful in defeating a fraudulent transfer claim. So again, there's multiple ways that you can attack these. I'm getting a flag here from the crew to move on. So tips for planning, things that we've covered throughout the seminar. Incorporate your planning into your asset protection and other planning, such as estate planning, corporate structuring, and
it's really not that hard. You almost always can do a corresponding estate plan. It may not be a lot. Some estate planners do asset protection. Sometimes we question, how they're related, but at least do them more or less at the same time. But I would tell you that corporate planning for entrepreneurs who get into doing asset protection for their personal and corporate assets is very integral with asset protection planning, and that's very easy to incorporate that.
Some other things you can do if you're involved in planning as a professional, obtain affidavits of solvency if you have questions about your client and their solvency issues. Where you have issues of property being transferred, you have questions of reasonably equivalent value, or where you have questions of, a claim has been made, but we don't know what the value of that claim is. How do I account for that claim? If I do any planning, can I do that? We've had that question. I'm a doctor, and I've been threatened with a malpractice suit. I think it's meritless. I think if I get sued, I'll win.
Insolvency.
But you want to make sure you account for that. Does that mean that the doctor can't do any planning? Not necessarily, but you want to go through a careful analysis and really try and figure out what the value of those claims are and avoid any insolvency or fraudulent transfer issues. And then finally, we talked about the legitimate supervening cause. Look for other life-changing, if you are making, especially if you're doing something where there's questions where you have creditors and it may be a fraudulent transfer, what's another reason for your transfer? Maybe you took on a new business partner or an investor, or maybe you had a change of a health circumstance like what Stuart testified about. People have stuff all the time. Find one and use that. And then understand, we saw these in the cases. Judges may look sometimes to substance over form. Judges might look at a debtor and decide, what were you really trying to accomplish here versus looking at the legalities. And then finally, if you're going to be doing planning, don't do planning and analysis and litigation. We recommend against that. We refer stuff out if we think there could be a situation where our own planning is going to be tested on certain circumstances. And we can talk more about that. If you have any questions, feel free to email us. Directly contact us through LinkedIn. We've got a couple minutes. We want to leave space for questions. And so I know we hit a lot of material today. We want to make sure that if you have any questions, feel free to contact us. You can reach us through our webpage, through email, or we'd like to have you all visit our LinkedIn page and then sign up. We have a discussion group. We will put written materials that further supplement today's seminar. And as we have developments that come about that may have impacted the things we talked about today, or as we go forward in the area of asset protection, we'll post those on the page as well. All right, well, thank you very much for joining us today.